We are live and on the record. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the June 15th, 2022 sitting of the Massachusetts Appeals Court. I'm Justice Eric Neyman, sitting today with Justice Peter Sachs and Justice Andrew D'Angelo. Calling our first case on the list today, docket 2021 E1012, Department of Children and Family versus Father and Mother. We will hear first from counsel for the appellant.
Good morning, Your Honors, and may it please the court. I'm Charles Levin. I represent the appellant father, who is asking this panel to reverse and remand the decision of the trial court. And father is with us this morning on the YouTube channel. This father has a particularly strong bond with this child, but it's more than just a strong bond. The record's very clear. Before the removal, he took very good care of this child. He had solid knowledge about him. He brought the child to early intervention, where he was noted to always be well-dressed, clean, appropriate, well-behaved, well-provided for. Always picked him up, dropped him off, or arranged for that. There's no doubt from this record about this parent's strong bond with the child, strong ability to take care of the child appropriately. That relationship, however, was derailed as a result of the domestic violence incident with mother. The court was wrong to rely on a relationship it considered to be fraught with domestic violence. This relationship was over by the time of trial. It was long over. The issue is moot and it's stale. Any subsequent contact between these parents was only incidental. There was no further domestic violence with anyone else, and the court was wrong to call domestic violence a condition likely to last into the indefinite future.
What do you say? I'm sorry. Go ahead, please.
Counsel, what about the fact that the father has other, at least restraining orders on his record, not just with mother? The judge credited that and took that into consideration. Why do you find that that is stale and erroneous in making her decision?
Well, the other restraining orders, with the possible exception of a restraining order from 2009 involving his ex-wife, was not a domestic violence situation. It didn't involve somebody in the house. Regarding the 2009 restraining order, we don't know anything about that. We don't know whether it was even contested. It was a 10-day order. It was not renewed. There's nothing in the record that indicates, anything that provides information to this court or the parties about whether there's anything that relates to actual domestic violence, whether or not the court found that because mother walked in, or not mother, the ex-wife walked in that day and made some allegations that she then dropped that were not true. So I think that to the extent that that provides any information to this court, it's such trivial information that it can't contribute to a finding of unfitness.
Can you address why it is that the 51B report that describes the videos furnished by the mother's sister could not be considered by the judge? I'm not sure I'm seeing why it's not primary fact. Both sources of the hearsay in the report were identified, the social worker and the emergency response worker who actually viewed the videos and saw the domestic violence incident, the father falling asleep on the child, the father under the influence, and so forth.
Well, it was identified only that one of the emergency response workers viewed the video. there were two emergency response workers. We don't know which one viewed it. I think that, to the extent that the court's willing to even excuse that, I think that the problem remains. This was one line mentioned in 151B that was not followed up on, other than that one line. There was no testimony about it. There was no introduction of or attempted introduction.
Could the judge not consider it as evidence of a second physically violent issue between the father and the mother, an interaction where the father attempted to harm the mother, and also with the father being under the influence and falling asleep on the child and preparing to inject drugs, that it provides a nexus between substance misuse and the child's welfare?
I submit, Your Honor, that this is such weak evidence that it doesn't meet that standard articulated in Zoltan and Progeny, that the evidence has to be clear, strong, decisive.
Clear and convincing evidence of unfitness, yes, but subsidiary facts need only be proved by a preponderance. And I don't know why this couldn't contribute to a preponderance finding of domestic violence and substance misuse.
Well, I think the problem is that whenever there's an investigation, there's a great deal of information accumulated in the record. Most of it is what might be considered extraneous information, to the extent that there's no follow-up to it. There's information that is not followed up in trial. There's no cross-examination about it. There's no direct examination about it. It's just there. And in this case, we have a record of hundreds of pages. Most of it was not followed up on, and this is part of that record. It would be different if one of those ERWs actually testified. If the video.
Counsel, we have a video in the record. Are you suggesting that we should not be able to view that video in our consideration?
No, Your Honor, that's a separate video.
Well, why don't we discuss that? That seems to be primary fact to the issue of the father at least yelling at mom, and could be construed as domestic violence. So why can't we consider that as the trial judge did?
You can. I concede that, absolutely. And in fact, at trial, father conceded that was evidence of verbal abuse. And but I think what we need to keep in mind is the mother herself testified that was likely taken in May of 2008, a good 13 months before the care and protection was even filed. And so its relevance to what happened between the filing of this case and the trial diminishes in significance greatly. I'm not saying you can't consider it, but again, does it rise to that level of being strong, clear, decisive evidence leading to a finding of unfitness? And I would suggest no.
Attorney Levin, your time has expired, but let me just check with the panel to see if they have any further questions. And seeing none, thank you very much for your argument. We've also read the briefs and we appreciate your argument.
Thank you.
We'll now hear from Attorney Diaz.
Yes, thank you. Good morning, Your Honors. May it please the court, Mirna Diaz on behalf of Mother Appellant in this case. Your Honors, it is no surprise that, and is very evident from the record, that Mother, unfortunately, in this matter, suffered from many mental health issues. The mental health issues, coupled with the incident of domestic violence, caused Mother, unfortunately, to become transient throughout this case. From the record, Your Honors, I'm sure saw that Mother was moved from shelter to shelter. And yes, at times, we do concede that Mother was unable to be, the department was unable to communicate with Mother throughout this case. And that was due to Mother's fears and, unfortunately, again, Mother's mental health issues. In this case, Your Honors, Mother did undergo a neuropsychological evaluation as the department required of her. And yes, we also can see the findings that it did take Mother 3 different appointments scattered over a period of time in order to complete that evaluation. But she did finally was able to get it done. And unfortunately, that was not shared with Mother, and that was not taken into consideration in the lower court's finding that this eval was not shared with Mother. Mother was unaware of the results of this evaluation, which the results of the evaluation, having a conversation with Mother at the times when the department was able to speak with her, would have possibly helped Mother in order to continue to obtain the care that she needed to assist her with her mental health issues. It was also, we also can see in the findings that Mother did have time management skills. Yes, Mother was late. Mother was late to visits. Mother had missed visits with her child. And in the neuropsychological eval, it also said that Mother was late to those appointments. Unfortunately, the only thing that the department provided to Mother was having her appear to places an hour or so earlier than her expected time. And the department, the court erred by not finding that the department is to work or provide specialized services for a person such as Mother in this case. More services had to be provided to Mother and tailored in a certain way so that Mother would be able to hopefully become fit if certain services had been provided to her. We are conceding the judge's findings, as Your Honor saw in my brief. We're not contesting those findings of fact. The only conclusions of law that we are contesting are 2, 3, and 4. Most importantly, the one in which the judge found that Mother's unfitness would continue to an indefinite period of time. Without Mother being able to engage or be provided services by the department, there is no way of knowing if Mother would ever have been able to actually become fit because these services were not provided to her. The department was armed with this neuropsychological evaluation, and Mother testified she was not aware that the results were in, and she was unaware of what it stated or what else she could possibly do. I'm not sure if the panel has any questions at this point.
Being none, we do not. You can continue, or you can submit on brief.
I will submit the rest on the brief. Thank you, Your Honor. Thank you for your time.
Thank you. And we will now hear from counsel for the appellee.
May it please the court. My name is Sandra Masselink, and I represent the Department of Children and Families. In this case, the trial court properly found father and mother unfit and terminated their parental rights, basing its well-reasoned conclusions of law on more than 200 separately numbered, specific and detailed findings of fact that were well supported by the evidence. This court owes substantial deference to the trial court's decision and reverses only where the findings of fact are clearly erroneous or where there is clear error or an abuse of discretion. There was no such error or abuse of discretion here.
Could you address the strength of the domestic violence evidence? The threats communicated to the paternal grandmother, as I read the transcript, were not threats of violence and were not directed at her. We've got a couple of 209A orders that lasted for less than 10 days in 2009 and 2013. There was swearing at the DCF workers, but that was anger. It wasn't threats. It wasn't attempts to control them, as we see in the domestic violence context. So how much of a continuing pattern was there here, particularly once the relationship ended? And the judge did not find that there was a continuing relationship. after the beginning of the case?
There was conflicting evidence in the record regarding when precisely the parents' relationship ended.
Okay, but the judge did not find that the relationship continued.
The judge found that there were interactions in the community between father and mother after the child was removed from their custody.
Right. But we're not going to find that as fact that the relationship continued just because the father says they ran into each other at a mall and they talked to each other after court. We can't take those findings about those interactions and say, okay, there's a continuing relationship here, therefore a continuing threat of domestic violence.
I think it's important to note that the abuse was both verbal and physical and stretched the entire period for which the child was in the parents' care. The verbal abuse between the parents was witnessed by paternal grandmother. There was evidence in the record of father's threatening behavior towards paternal grandmother and angry outbursts towards the social worker, as you noted. And the physical abuse in the record did conclude, as far as the record reflects, with the child's removal from the home in June of 2019. Also, as was discussed previously, there's video evidence of the abuse between the parents. And it's important to note that the case law is clear that exposure to that type of domestic violence causes a child to suffer a distinctly grievous kind of harm. And the evidence is clear here that the child was exposed to that volatility and violence in the parents.
I wanted to ask about that. The judge found that she didn't believe I think it might have been the mother's testimony that the child didn't hear the argument. Does that constitute evidence that the child did hear? I mean, this is an infant, that the infant did hear the argument?
The judge noted that the incident was sufficiently loud to cause a neighbor to call the authorities and drew an inference in part based on that such a dispute must have been loud enough for the child to have been aware that something was taking place. And again, the record didn't simply reflect that incident of violence or domestic disputes while the child was present in the home, but many other incidents of such unrest in the home as well. And again, here, the past conduct of the parents is relevant to the judge's determination of current unfitness. The court's not required to wait for some inevitable disaster to occur, but rather can weigh the past pattern of conduct that was uninterrupted here in making a determination as to current unfitness of the parents.
Can you tell us what nexus there was between substance misuse, whether alcohol or something else, the father's substance misuse, and any abuse or neglect of the child, other than the video described by the emergency response worker to the person filling out the 51B? I'm not sure what I see in the record about that.
5 of the 6 51A reports here reflect supported allegations of father's substance abuse. For example, at Record Appendix 279, and the court below also found that the violence and volatility in the parents' relationship escalated when the father was intoxicated. That's at Finding of Fact 178. So I think the record does reflect that father's drug and alcohol use continued after the child's birth and contributed to the events that caused the child's eventual removal from the home.
What about any evidence of substance misuse, including alcohol, after the child was removed? What evidence is there in the record to support that?
As recently as 2 weeks before trial, paternal grandmother testified that she smelled alcohol on father's breath. Father tested positive in his screens for benzodiazepines, which he had not reported to the department that he was prescribed after the child's removal and right around the time of his stipulation of unfitness. He also screened positive for cannabis in November of 2020, again, after the child's removal, after his stipulation of unfitness, and shortly before the beginning of the trial in this case. There's also testimony and evidence in the record that paternal grandmother and mother believed father to be an alcoholic, and the court expressed concerns about father's ongoing consumption of alcohol, particularly in light of his methadone treatment and the methadone treatment facility zero tolerance policy for consumption of alcohol. I'd like to turn now to some of the other factors that the court considered in determining that father was unfit and terminating his parental rights. We've discussed the incidence of domestic violence and father's history of drug and alcohol use. Father also failed to address some of these behaviors and engage in the services that the department provided, which would have reflected a commitment to prioritize the child's needs and to improve his parenting skills. He, for example, declined to participate in a batterers program or even undergo an evaluation that would have determined whether such a program was necessary. And that inconsistent participation overall and lack of noticeable improvement supported a finding of unfitness. I'll note also that father failed to maintain stable housing, and it was the cumulative weight of the evidence of all of these factors that led the court to determine that father was unfit.
On the housing instability, how were DCF's efforts reasonable there to assist the father? I mean, surely DCF knew, we know that DCF knew that he was having difficulty maintaining housing stability. And I ask not so much on reasonable efforts per se, but on what Ilona says that we can consider, a court can consider the department's reasonable efforts in evaluating whether unfitness is permanent, where the department really didn't do much to help him find housing. How do we know that his housing instability couldn't be remedied if the department did something?
Your Honor, the issue is not ripe for consideration here because father didn't raise below any argument that DCF failed to provide adequate services with respect to his housing or any other.
Yeah, but Ilona makes a different point. We're not evaluating reasonable efforts itself. We're evaluating whether the father's unfitness is permanent. And do we have any reason to think that it is if DCF never offered an assistance?
I would point the court to the overwhelming evidence in the record that father failed to take the department up on many of the services that the department did provide. And there's no reason to conclude that the results would have been different had the department sought to extend additional assistance with respect to his housing instability in particular. I see that my time has expired. I'm happy to take other questions, particularly as may relate to mother's arguments. If there are none, then I'd conclude by asking the court to affirm the lower court judgment terminating father and mother's parental rights.
Thank you. Seeing no further questions, we will move to attorney for DCF, Attorney Cohen.
Good morning, Justin Cohen for the child. The child
My
was
apologies, counsel for the child. Thank you.
The child was removed from the parents on June 29th, 2019, and he was in 2 short placements, and then he was with the pre-adoptive parents. And he's almost 5 years old now. It's a kinship placement. He's bonded to the pre-adoptive parents. He calls them mommy and daddy. He also considers his cousins, ages 9, 17, and 18, to be his brothers. He's up to date medically. The pre-adoptive parents have also taken him to see an eye doctor and an ear doctor. Now he's healthy and energetic. He likes to play outside, blow bubbles, and go for wagon rides. The pre-adoptive parents want to adopt the child.
Was there any evidence that he wasn't doing well before removal?
There was the domestic violence, and the consensus was that the parents should not be living together, but they kept living together. And they barely did any services. So previously, this child was anemic and delayed in his speech, but now he's up to date. He's up to date. He's meeting his developmental milestones. By contrast, when the child lived with the parents, their place wasn't even close to childproof. The child choked on a penny on the floor. He choked on a pair of ear pods. There were various pills all over the table within his reach, and somebody left a razor blade on the floor. Mother had untreated mental health issues and substance abuse issues. Father had substance abuse issues while he was on methadone, and there was domestic violence between the two. There were a lot of police responses. The consensus was they shouldn't continue living together, but they kept living together. And they barely did any services. Eventually, father was living in a trailer in the forest without any plumbing or toilet. Or he was living in his truck and consuming alcohol. Mother moved 5 times within a space of a half a year. I asked this court to affirm the trial court decision, placing the child with the pre-adopted parents, because this child deserves to be adopted. I see that my time is almost up, so if there are are there any further questions?
And seeing none, thank you, counsel. I'd like to thank all counsel. Actually, the panel would like to thank all counsel for their very thoughtful briefing and your helpful arguments, and the case is submitted. Thank you. And this concludes our session.
Thank you.